issues on disability
Please spotlight
matters.
the interpreter.
Yeah, can you spotlight the interpreter, please?
Yes, Rajiv
So,
sir, just one
Professor, yeah,
Hello, my mother is saying that you should spotlight the interpreter because the deaf people aren't able to see the interpreter.
Yes, we're just on it. Give us a few seconds.
Okay, thank you.
so the Disability Rights Initiative of HRLN has been closely working and being guided by Professor Dhanda. She led a process of law reforms where we undertook almost 7 to 8 national consultations on the process of law reform. She also was the legal consultant to the expert committee drafting the new disability law. It's great to have you here, Professor Dhanda. Professor Dhanda is going to be speaking to us on what are the issues around legal capacity, and is legal capacity really the gateway to total inclusion of people with disabilities? So welcome to you again, Professor Dhanda, and I hand over the floor to you.
Thank you so much, Rajiv. Well, let me start by saying that I have been for a while, let's say, being a little shy of speaking again on disability rights, maybe much more in the reflective contemplation mode. So did not feel that I was wanting to come and have, do a public lecture and answer questions. And also because somewhere, I have been someone who's been advocating universal legal capacity for at least 10, 15 years. And yet suddenly I've encountered a whole body of writing, which is getting me to think that maybe this position needs more nuance. So in the midst of all this hesitation, I got this invitation from Rajiv, and for the longest time I procrastinated. Then I ultimately felt that if skepticism can be shared, or if fresh thinking can be shared, it can be shared with friends. And so I wrote back to Rajiv, apologizing for my bad behavior and saying, okay, I think I'm ready to talk. But I don't know whether you are a collection of lawyers or it's a combination of lawyers and activists. And to a great extent, when we talk in law, we talk way more definitively. It's like we're very certain people. We know the yes and the no's and the blacks and the whites. So to that extent, I suppose maybe as a professor of law, I can bring in some shades of gray. I can sort of say that, listen, maybe everything is not yes and no. Maybe we should start thinking about the whole issue of inclusion rather than to just think in terms of legal capacity. We should see what is it that legal capacity gives us and what is it that it does not. Or where is it that there is a difficulty with trying to bring in inclusion through legal capacity. So to the extent I'm happy to field questions or concerns that you have with the existing model. But what I am presenting to you today is the existing model, the way in which it has evolved over a period of time. What is it that the CRPD has done? And then some of the struggles so many of us are having of trying to get that universal inclusion in the way in which the polity and the law and the society functions, and where is it that we're getting torpedoed on a very constant basis. Within that narrative, then I'm asking you, primarily relying on a whole range of European scholars, because somewhere in India, primarily because of the access of language, we look much more at Anglo-American work. But this is a whole range of European scholars who are raising questions or who kind of providing suggestions for how inclusion can happen through modes and routes other than just looking at legal capacity. I'm not doing a very detailed exposition of those positions, but I am wanting to familiarize you with that this is another way of looking at things, and to ponder with you as to whether this other way of looking at things can be kind of joined in with that which we are more familiar. You know, the CRPD, the entire jurisprudence around legal capacity, some of the battles that many of you have been fighting both in courts and outside, and battles that I'm in total ad idem with as far as the object is concerned. My only question somewhere today, which is the reason for the title, that is legal capacity, the gateway for universal inclusion, is that are we putting all our eggs in one basket? Is there some kind of a case for looking around and looking beyond legal capacity? That's primarily the thrust of my lecture. Like I said, it's not a very yes-no kind of lecture. It's not black and white, but hopefully it is reflective. And it's more like, I would say, I'm sharing my own reflections, some of the thinking that I've been doing in the recent past, in a community of friends, which for me is like led by Rajiv Raturi, with whom I have been working. We even did a book together. So it's like, I suppose our common concern is the reason why I'm emboldened, Rajiv, to do this presentation with you and the Center for Constitutional Rights. I'm happy to sort of be the, I don't know whether I'm the inaugural lecturer or not, but to be a part of this series. More like in the sense of, I think this is time wherein all of us across the polity, and depending on whichever kind of body of citizenry we belong to, we seriously need to think in terms of our constitution, as well as like what is the way in which we can build connectedness. I think disability can be leading the way, primarily because we have been amongst the people who were most left behind. So now when so many other people are having this experience of exclusion, I think it may be a good time to start a conversation of inclusion, and for it to be happening, being led by disabled people and their groups is, I think, only opposite. I've always said that disability rights is an excellent Trojan horse through which larger questions of inclusion can be spoken about. So as I'd already said that, you know, what I'm planning to do primarily is to look at the whole question of, okay, how do we look at legal capacity? How do we understand legal capacity? How has this concept evolved over time? Its more recent expansion in the context of the CRPD. Then to ask this leading question, which is, I suppose, in some way, the fulcrum question of my presentation, that does expansion make for universal inclusion? And lastly, I'm going to sort of point you to other alternatives to inclusion other than legal capacity, and to sort of get us to think whether we can do some kind of a joinder of these other alternatives, along with the sort of this new paradigm of legal capacity, which the CRPD has brought in. It's like, I don't even think now it's become such a common kind of exposition, which is very, very, any kind of writing around legal capacity says this. Even the general comment, when it spoke about Article 12, spoke of the two major components of legal capacity, that, you know, if you have legal capacity, you are a holder of rights, and two, you have the capacity to act. To be a holder of rights is, of course, to say that, yes, you know, the law recognizes that you have certain kinds of entitlements. A very common example one often gives is that, you know, when you denied a whole range of, especially all people with all disabilities, all kinds of impairments, whether it was physical, mental, sensory, you were denying them, say, the right to inherit. And this particular disqualification subsisted in Hindu law for the longest time. So you were speaking in terms of, and it didn't really matter what was the nature of the impairment, whether you had a physical, a sensory, a mental, and intellectual impairment, you were not somebody who could, in fact, any kind of a physical defect or mental defect excluded you from being any kind of an, you know, you couldn't be inheriting property, managing to dur ki baat, you know, it's like but even like you couldn't you couldn't be a holder of rights. That's one component of legal capacity, which I suppose this disqualification went away for a large number of people with impairments. And it's to be a holder of rights was, of course, not just something confined to people with disabilities. It as much extended to women. It was there, the way in which you looked at how children operated in the world, then the whole phenomena of where you spoke in terms of people in enslavement or bonded labor, or what I'm saying is not to be a holder of rights is not something which was only limited to people with disabilities. There was a large community of people to whom it extended. The other dimension of legal capacity is the capacity to act. That is, you may be a holder of right. That is, you could be inheriting, say, that property, but you can't manage it. You're not the one who can buy and sell it. You're not the one who can gift and will it. So it's the other dimension of like somebody else can do it in your stead, but you can't do it yourself. And so this package of how you understand legal capacity is something that I think all of us at this point of time are kind of familiar with. I am starting with it primarily because it helps to have a basic building block around which you want to have your other conversation. And the problematic dimension, when I come to the CRPD and the developments that have happened there, all the problems are happening around the capacity to act. Nobody, not even when they tried to, all the tussle which happened in relation to Article 12, no one was being denied to be a holder of rights. But you're saying, no, but everybody can't act. And of course, the biggest problems came with people with intellectual, developmental, and mental disability. So you brought in that particular category of people were the ones whom you totally ousted, but some level of incapacity to act was also, I think, imposed upon people with sensory disabilities, but we'll come to that in a moment. So this is the first, you could say, first building block I'm putting forth for my conversation, that this is how we understand legal capacity. And the fact that this exclusion has not been limited to people with disabilities is also to demonstrate that legal capacity has always been a legal construction. It has been something that the law, depending upon what kind of social, political, economic system you were advocating or you had formulated or constructed or established, according to that, you decided who has and who doesn't have legal capacity. Now, this is an important, it's an important finding or an important limb in my argument that legal capacity has always been a construction of the law. It has nothing really to do with what an individual person or a category of people or a group of people can or cannot do. It's more to do with the fact of who the law wishes to recognize and does not wish to recognize, to whom you want to grant this autonomy of being able to organize your own life according to your own lights, or who is it that you want to keep out? So when you speak in terms of, say, the exclusion of slaves, or in our country, when you talk in terms of an entire class, entire caste of people who were denied the right to education, who couldn't possibly be having the freedom of movement, who were, very, very strict kinds of norms, and many of them even subsist till today, norms of, co-dining and consanguinity, all of those kinds of things, they had to do with that you had set up a particular social system. You wanted to privilege that caste system in a specific kind of way, and accordingly, you decided who has and who doesn't have the capacity to participate in that system. Now, Roscoe Pound, a major American jurisprudent, brought out a book on persons. He has some 12, 16 volumes of jurisprudence. In one of the volumes, volume 4, he brought out a book, brought out that volume on the whole notion of personhood. Now, the reason why I'm not particularly feeling the need to address you on American jurisprudence, my only reason for making this reference and sharing what Pound found is that this book is Pound's narrative of looking at how personhood evolved in different points of time. So he began with, who did the Romans consider to be a person? How exactly, what were the rights and entitlements of the slave? Was the slave not a person before the law in all things? Or was he a slave, was he a person for some things and not for other things? So there was like, he talks in terms of that how, the slave actually had, if he was cruelly treated by his master, he had certain kinds of entitlements on being treated cruelly. Or, like what is it that there were some certain kinds of basic minimums that the law provided for. The slave couldn't own property, the slave couldn't be like, couldn't vote, couldn't do a whole range of things, couldn't participate in the polity. But in relation to between the master and the slave, there were certain kinds of entitlements were still given to the slave. The reason why this is of importance or significance of interest is basically because it was what the slave could do or could not do had nothing to do with the physical person of the slave. It had more to do with the fact of that if you had a slave society and you had masters and you had slaves, then evidently you needed to apportion as to who could do what and who couldn't do. And that's the manner. I mean, I'm giving this to you as a very striking example of what you mean by legal capacity. That is, you are recognized as a person before the law for some things, and what the law permits you to do or doesn't permit you to do. That's the manner in which we end up constructing legal capacity. So Pound, he speaks in terms of the slave society, then he speaks in terms of, the entire, what was seen as you could say the law of the patria familias, the person in our Hindu law, you would say the karta, or you talk in terms of the person who's the head of the family. And so much so that this patrias potestas, he had that kind of status in the law that everybody, including adult sons, were all subject to. Nobody at all had any kind of recognition before the law. They were all sort of people who subsisted under the patrias. And it was like, so you couldn't possibly be, organizing your own affairs yourself. It was, everything had to come mediated through this father figure. And I mean, it's a very interesting finding that you started out with, where you were also excluding, the adult majors, the adult son, that the daughters were excluded, or the married and unmarried women couldn't be doing things, is something we are familiar of even till today. But that there was a time at which even the adult son could not be doing things is something which Pound brings out in his exposition. And my reason for talking about this is that he demonstrates that how the economic, political, social organization of a society greatly determined who has or did not have legal capacity. And then as he keeps on going, he talks in terms of the Hindu caste system. He talks about it, of course, in very unproblematic terms. He also speaks in terms of the, the feudal society and the relationship between the lord and the serf. And each one of them as to who is included and who's excluded. At the end of it all, he concludes by saying, now that, we've reached this more, you could say, liberal capitalist society, all adults have legal capacity, and excepting for those whom we are excluding by reason, as a measure of protection, by reason of their physical or mental impairments, that's the only thing which is remaining, and that Pound, of course, did not find problematic. Please note, he was writing in about, the 40s of the previous century. And he was, to that extent, the way in which he did this entire narrative, he was demonstrating that legal capacity is connected with the sort of social, economic, political system you have. But the fact that in this social, political, economic system, you were, excluding people by reason of the so-called impairments that they possessed, whether physical, mental, sensory, Pound did not find that problematic. So he said, excepting for this, all else is sorted. And evidently for me, the story in some way starts from there. But I'm just wanting you to take this one idea from me on this whole exposition I've taken from Pound, because this will still hold relevant when we discuss further as to, okay, what is it even as we recognize universal legal capacity with support under the Convention of the Rights of Persons with Disabilities, who else are we still keeping out? What is it that is happening there? And I want you to connect that or relate that to this exposition or this very, very brief kind of synoptic narrative I have brought out from Pound, and how at different points of time, legal capacity was very much an instrument of social control as to who you wanted should have a voice in a society and who you did not want. And the fact that Pound found the exclusion of people with disabilities as unproblematic is very demonstrative of the sort of you could say the sort of jurisprudence or the kind of philosophy which was very commonly propounded when we talk in terms of the Enlightenment, or you speak in terms of a whole range of liberal theorists. There is this huge emphasis that they put out on reason, and in the possession of reason or the absence of reason, determining whether you are human or you're not. In fact, the entire exclusion of people with intellectual, mental, and developmental disabilities happens basically from their alleged absence of reason. So because you don't possess reason, hence you can't possibly be recognized as a person before the law. Hence you can't possibly be controlling your own life or managing your own life. Therefore, you have a guardian or you have someone else who looks after your affairs. And in looking after your affairs, they may they may be guided by your best interest, but they are definitely not to be guided by your preferences or how you would want to live your life. And all of that was the way in which we were talking in terms of legal capacity for people with disabilities till the convention came. And now in the convention, and that's wherein I go to my next part of what I'm saying, that you speak in terms of, I'm called in my own notes, I'm thinking of this as a recent expansion of legal capacity. Of course, the CRPD is also now 10 years old, so it's not that recent a kind of phenomena that you're speaking of. It's more than 10, in fact. So, but it's like what you did have, what the struggle was when we were debating or deliberating on legal capacity in the Convention on the Rights of Persons with Disability, that when it came to physical, when it came to sensory, there was no real dispute on the recognition of legal capacity. The fact that sensory disabilities had their own body of exclusions, whether it is like operating your own bank account or whether it's the kind of confidentiality you could have in relation to maybe how you exercise your franchise and your other political rights, those were still disputed questions. I mean, technology to some extent has taken care of some of these things, but it's not like, even with the sensory or physical disabilities, it was all sorted. It wasn't like that there was no exclusion of any kind happening there. But the biggest struggle in the making of the CRPD came primarily around the whole issue of mental, intellectual, and developmental disabilities. Intellectual and mental, way more, to be saying that, if you do not possess reason, if you can't discern between, if you lack that, the cognitive capacities which are required to make decisions, how can such and such person be granted legal capacity? You can give them if you want, you can provide for the capacity to have rights, but you can't possibly grant the capacity to act. So the definition with which I started, that, okay, this is the common construction of legal capacity, the capacity to have rights and the capacity to act. You had, you actually had a footnote being put into the convention, which was sent to the General Assembly. You actually had a footnote being put which said that in Russian, Arabic, and Chinese, legal capacity will mean only legal capacity to have rights and not legal capacity to act. That the footnote got ultimately dropped, and that it became like, oh, no, we're not talking in terms of any kind of, there's not going to be a difference between the various UN languages. And it's actually, we're recognizing everybody's legal capacity. That was the manner in which, the English text got settled. But if you look at the translations of that text, you would find that this distinction between capacity to act and the capacity to have rights was retained in all of the languages, whether it was Arabic, whether it was Chinese, whether it was Russian, the manner in which the translation happened, this particular distinction between capacity to act and capacity to have rights was retained. In English, of course, this particular distinction was dropped, the footnote was dropped, and you came up with this, the Article 12 of the Convention spoke in terms of universal legal capacity. It also spoke about the fact that, you could seek, if you needed support for the exercise of the legal capacity, it was like, it was a choice of the person with disability and a duty of the state, but you couldn't sort of, like virtually impose that support on people. To take that support or not to take the support was the choice of the person with disability. You couldn't, sort of insist upon that unless and until you take this, that, or the other support, because if you were to do that, you would bring guardianship by the back door, and the whole business of recognition of legal capacity would become more like an eyewash. Also, the other thing which is important to appreciate in the context of support was that you were for the first time also acknowledging the fact that you do not have to see capacity and vulnerability of any kind as oppositional. As humans, we need each other. And if you take that help from each other, from, like one takes from the other, that should in no way negate the capacity that you possess. That is a very core kind of, you could say, philosophical point which the convention was making. At the same time, we're all aware of the fact that whilst some laws were changed in our own country, also if we look at the manner in which legal capacity has been addressed in the Persons with Disabilities Act, as well as in the Mental Health Care Act, you find a very, a very anomalous kind of exposition. At one level, you are saying, yes, we recognize legal capacity. At another, you actually speak in terms of, partial and total guardianship. You speak in terms of, you say that, all right, if you can't, I mean, the draft from which the ultimate legislation was made was speaking in terms of that you begin with a changeover from a total disqualification to a limited guardianship to a total capacity. It did not at any point envision that limited, limited can become absolute. You can't graduate from a limited guardianship to an absolute guardianship. The only kind of trajectory which was being put forth by the expert committee which the government of India had set up to look at a reformed law was that you move from an absolute incapacity to a limited one to then absolute capacity. That was the trajectory which was being drawn. But when the legislation itself got enacted, it was made a two-way process. It was like, oh, you can, if limited is not enough, then you can be given absolute. The fact that a certain kind of a presumption was being brought in by the convention that all people were capable and you did not really require, all people possess legal capacity, and you didn't have to in any which way provide evidence of that capacity. It's a presumption of the law that you're capable. Just as today, there is a presumption of the law that if you are a person of unsound mind or a person with mental illness or you're a person with some kind of an intellectual deficiency or whatever, then you could be seen, like your legal capacity could be questioned. This was the position of the law before the convention. In some manner, what we landed up doing in the garbled kind of manner in which we enacted, and possibly because this particular disquiet or uneasiness of that, how can you be talking about everybody's capacity was caused for this changeover to happen. So you muddled it through and you actually said, oh, guardianship can be seen as support and total guardianship can also be seen as support. Of course, we are recognizing your legal capacity, but it's like you're recognizing legal capacity in a manner wherein, you're just recognizing the shell, the kernel has been taken out. And that particular, the fact that, okay, in appearances, we are doing what you are doing, seemed to be sufficient. It was felt that nothing more was needed. And it's here that, along with what is happening in our own country, you found that there were interpretative declarations which were filed before, the United Nations, saying that, oh, in our opinion, substituted decision making or guardianship was something which is permissible by the convention. Now, they were not making a reservation. They were actually saying, this is our interpretation of the convention. The general comment, as well as all the other concluding observations which have come in from the treaty body, have been constantly negating this position. They have been insisting on the fact that no, legal capacity here is universal. It means that you can't be putting in these caveats. You can't be sort of excluding a whole body of people. And yet, each day just as you're finding people are coming up with, with reservations on this universal capacity, you're also finding a lot of imaginative articulations coming in from how you can think of legal capacity in an inclusive manner. So one, of course, is that, that people keep asking, what about people in a coma? What if the person is totally non-verbal? If there is no other way in which you can really understand the will and preference of an individual, what do you do there? So you've come up with things like that, one, there's a large amount of material which is getting generated, which is speaking in terms of interpretational, like you speak in terms of that there's a whole range of choices that people have made over a period of time, and those choices should be guiding the manner in which you see what would be the best possible interpretation of what that individual wanted. The will and preference, as demonstrated by the actions of an individual, should be seen as guiding whatever decisions you're taking vis-a-vis that individual. But that person's will and preference, and not the best in what is in the best interest of the individual, should be guiding how decisions should be made. So if I was to look at the recent expansion of legal capacity and to look at this tug-of-war which keeps happening, where people are pulling this or that side, what you are finding somewhere is this, that whilst there is a body of interpretation or a body of action or policy guidance or programmatic interventions, which are trying very much to see that no one is left behind and everybody is included. You also simultaneously have, be it in the law, be it in policy, be it in programs, be it in everyday articulations, reservations on this universality. You actually had a range of, I think some 8-10 psychiatrists who had done this personal comment in Lancet, a major medical journal, wherein they were saying that, oh, this recognition of universal legal capacity is actually going to be a retrograde measure. It is all the progress that we have made in the treatment of mental disorder is going to take a back seat. And it was supposedly a personal communication, but it was widely made available. And it was like for once, Lancet didn't follow its own, copyright policy, and it was virtual open access to this particular communication, and everybody could be reading it. And it was like to say, oh my God, how much harm you're going to cause if you are going to be recognizing capacity possessed by everyone. And it's in this turmoil of yes and no and inclusion and exclusion that I have been like wondering and thinking that in the face of so much resistance, was legal capacity the best medium through which we could have talked in terms of universality of inclusion? Now I'll kind of explain what I mean by going back to that entire pound narrative I shared with you, and the fact that at each point of time, depending upon what kind of a system was established in a particular country or society, you defined, the power of definition. Whoever had the power to create meaning, whoever had the power to define, decided who is in and who's not. More importantly, the very fact that you had this opportunity to define. And I think all law people in the audience would recognize that definition by definition is about creating boundaries. It's about who comes in and who stays out. So even when you and you look at that bound narrative, you find that, all right, say you brought in the son, you kept out the daughter, you brought in the, till what is a period of time till which married women couldn't possibly be owning their own, they couldn't work, they didn't have the power to have their own domicile or their own personhood. They were totally tied up, especially the entire business of coverture kind of so tied up the woman with the husband that she didn't really have a persona of her own. So when you came into Convention on the Elimination of Discrimination Against Women, as one example, you spoke in terms of that women having the same rights as men. When you came on the Convention on the Rights of the Child, you started to say, no, you can't just speak in terms of best interest. You have to also talk in terms of the evolving capacity of the child, which means that there would be times and things for which what the child has to say for himself or herself, or children have to say about themselves, that's a more appropriate way to formulate it, has as much to be taken note of. What I'm wanting us to appreciate is that in this the moment we are engaging with legal capacity, you might bring some people in who, in the sense of with what kind of struggle or what kind of agitation or advocacy, you get yourself recognized. You'll still find that there's a whole range of other people who are standing out, who don't get included. And today we're talking in terms of stateless people. We're talking in terms of, exactly if you are a person without a state, exactly what is your capacity? Where do you stand? If you look at the whole realm of labor law, it is about the fact of that if you are, whether you're an organized or an unorganized worker, or you are like an undocumented worker in some spaces, you're a worker, all right, your work is being taken, but the law doesn't recognize you. What I'm trying to put out to you is that legal capacity as a concept has some kind of a canker in its lodged inside it, which kinds of has a tendency to bite. It's like, when you are on the platform and you're looking to get into the train, you are only concerned about the fact that I get into the train. The train has this much capacity, you get into the train, and then this many people get left behind is not something that you at once think in terms of, then how do we work out this whole notion of, after all, why do we want legal capacity? We want legal capacity to be able to participate in a society, to be able to have voice, to be able to interact, to be, to say that, no, someone else doesn't decide for me. I am an integral part of the community, and the community has to think of everybody who's in the community. And then if you come up with a construction, which sort of all of the time, okay, at this point we can say, we're still struggling. We're still struggling with about the recognition of people with intellectual and mental, capacity. You may have certain scholars who may say that in countries like ours, the law doesn't matter. It's not actually who the law recognizes or doesn't recognize that matters. What matters is the kind of relationship that subsists within a society. But the fact is that if those social relationships also don't recognize a body of people, and the law also doesn't recognize them, then they're really speaking without recourse. And we are putting our money on a way of operating. And I'm not sort of saying it's totally irrelevant. I'm just asking you to reflect with me as to the limitations of this particular technique, because it as it includes, it excludes. Who it brings in, who it keeps out. And that worries me. It's like, it's a constant kind of a struggle. It's like, if it is a recognition of the law, then to implement that recognition also, I go to the law. And when I go to the law, I go to a set of judges, I go to a set of people who constitute that legal system. And a large number of people who constitute that legal system endorse some of the prejudices of society which have been encoded into the legal system. So I am going for relief to a system which in some very core foundational way actually believes in the prejudice I am challenging. And that's where my worry comes. And that's where the question of this presentation comes. So as I kind of, what I want to like very quickly sort of share with you is that another way of looking at the whole, when I'm talking about alternatives to legal capacity, what I mean by is alternatives to processes or philosophies or theorizing, which is bringing in inclusion by mechanisms which are other than legal capacity. That's what I mean by when I'm talking in terms of alternatives. It's like to say that, okay, can we philosophize in a manner? Can we sort of talk that kind of bhasha, which is like inherently is inclusive? It doesn't need you to be recognized somewhere or the other. It doesn't need something or the other to happen for you to be included. And it's like, there's this theorist called Plessner who wrote in the 40s, but because he did not write in English, it became like, that the exclusion, it's a kind of exclusion which happens in terms of ideas because it was written in a language which was not as widely present as, when, or at least our access to it. And he sort of speaks in terms of like, being a body rather than having one. And he's saying that he doesn't agree to this factor of that there is some human essence. Go back to the entire business that you talk in terms of whether you talk of Descartes or the entire Enlightenment school, or even in our own this thing where you give this kind of privilege to reason. So you say that, is not the expression, human culture is not the expression of a given human essence, but precisely it is the index of the radical absence. The point somewhere being is that we all get constituted by our specific cultures. So to say if the culture is in a specific way, who it recognizes and not, that determines, like who is seen as human and not seen as human. Whereas in fact, what your inherent humanness is something which is pre-culture. So before I complicate you and myself, I confuse you and confuse myself, let me just say what they are somewhere talking in terms of that, the fact of you being a body and that body experiencing something in the flesh, the life that you experience, this is something which is common to all of us. And you're not talking in terms of a particular kind of body, but that body which exists and its interaction with others. That's how you create a community. You speak in terms of, you think of human rights as innate to individuals' embodied life, to the bare life, what they call as zo, rather than the bios, that is the characteristics that, that are recognized by legal process. So the kind of stuff that we have when we are saying, okay, if you possess reason, if you can distinguish between right and wrong, then you are the kind of person who possesses legal capacity or not. If you can, if you can understand the nature of an action, or if you entering into a contract, you understand what is the transaction that you're entering into and what impact it will have on your interest. You've come up with a whole range of tests. I'm just kind of ad hoc quoting them to you to then determine, okay, whether you are a person before the law or not. On the other hand, they're saying is that, just your bare life, that is the body that you possess, what you experience in life through your flesh, and the experience of life itself. So like as a body, you can see yourself from the outside as well as feel yourself from the inside. So you are saying that this experience is something that is possessed by all humans, and you become and that's the kind of theorizing where you're not speaking in terms of any entry point or any kind of a gateway that you have to cross before you can be considered a person and possessed of legal capacity. Also, because that deserves a lecture of its own, and to talk about it as a kind of a footnote at the end, what I'm somewhere wanting you to appreciate is that the stress that Plessner is putting forth is about the business of creating communities. And you're saying the creation of communities is necessarily wherein your interact, or the community is not being created on the basis of ethnic ties. It's not being created also on some rational ideals, that you possess reason or you don't possess reason. I mean, the entire Rawlsian formulation of, like, when he talks in terms of creating a society, the presence of reason is something. Kant or a whole range of other scholars give that kind of emphasis to the presence or absence of reason. Plessner, on the other hand, is not saying that you can't talk in terms of a community only between people who are related to each other, our entire, or who have some kind of association of blood and caste, blood and flesh. So your entire caste system and the business of, who you are permitted to marry or not marry is that kind of a thing. Your privileging of reason becomes another kind. He's saying that somewhere the norm for creating a community is to have an interaction in the public space of individuals that share nothing between them. So you are in fact talking in terms of creating a community of people who are like you and totally unlike you. And how you sort of set up that interaction is the way in which he's saying that the human society should operate and function. For the purposes of my argument for today, I'm just stopping here. Maybe another time, when as the lectures proceed, I wouldn't mind coming back and just doing this part if people are interested. But at the moment, I'm only putting this forth to say that, we have spoken in terms of inclusion to be happening through the medium of legal capacity, who the law recognizes, what the law permits you to do or not do. Our study of this entire business of legal capacity demonstrates to us that the construction of legal capacity is itself a very politically fixed exercise. It has a lot to do with the kind of economic, social, political structures within which we are living. The theorizing is also accordingly. Is it kind of worth our while to start looking at unmediated inclusion, which is what I was trying to narrate to you with, Plessner and Esposito and other kinds of theorists who are speaking in terms of a creation of a community which just happens, which is just there, which doesn't require you to go through certain kinds of hoops before. It's only if you've crossed through those hoops will you be seen as a person. It's more like the body that you possess, the experience that you have, the life that you live, all of them qualify you to be seen as an integral part of a human community. My question to you, or the discussion I'd want to have, and I'm not in any which way saying that we need not discuss some of the battles that we are having with the paradigm that we are all been trying to obtain recognition for. But I'm also somewhere saying is that sometimes it's like, when you're serving or doing a job which is possibly making you unhappy several days, it's useful to have your resignation letter in your pocket and keep working. Similarly, I would somewhere say that when you are working on a specific idea or a theory, to have an alternative also, also to, let's say, engage with an alternative in some ways makes some of the frustrations that you have maybe facing with what you're doing more bearable. I have found this reading that I'm doing, and I'm still doing it, to be in some manners very liberating, because it also opened up other ways of looking at the whole phenomena of inclusion and human rights. So it was basically that which I wanted to share with you. I'm open to questions. Thank you so very much.
Thank you so much, Professor Dhanda, for this excellent lecture series. We'll open up to the floor now. Varsha, can you sort of moderate?
Yes, for sure.
Please, thank you.
Are there any questions? I would like to read one comment by Geetu. She's written, till recently, some banks did not give loans to women unless they had a male as a co-borrower. Ma'am, you're on mute.
That's exactly the point I'm making, in the sense of like exact who you recognize or who you don't recognize, the manner in which those rules get constructed. This particular rule is very much a fallout of the patriarchal system where you believe that women had to be necessarily subservient to men. And that's the manner in which you constructed your entire thing of who's eligible and who is not. And when we struggle, what we ask for, Geetu, is basically this, that we'll say, you change that rule. You alter that rule and you see to it that I'm recognized. And often what lands up happening is that maybe this rule changes and some other stuff lands up coming in, because prejudices have a way of reappearing in several sorts of ways. I am not in any which way, let me make it very clear. I'm not saying that this struggle should not happen. But I'm also what the thrust of what I'm trying to say is that some of this has a lot to do with that if you are, say, in an unquestioning manner, continuing to engage with patriarchy, if you don't ask those questions and you just worry about this rule, then that patriarchy will give birth to other kinds of rules who are excluding some other person in this or that way. That's the point I'm somewhere trying to make, that your underlying philosophy with which you're operating is necessarily going to keep seeing how you can be, how the full participation of women and of men in a manner which is other than how patriarchy wills it is something which is not acceptable. It's not just about women. Huh? Let's be very clear. It's as much in terms of that, all right, if you are a man, then you have to be a particular kind of man. And if you are not that particular kind of man, that's not acceptable either. Well, the law, Vasha, is it okay? Should I look at the question and answer it, or you want to moderate and combine or do something?
Am I audible?
Yes.
Yes.
Yeah, I would like to read it out loud for everybody to know the question.
Sure.
So Harish has written, I'm a psychiatrist and I'm curious to know how the law looks, the relation between unsoundness and lack of legal capacity. And Harish has added, I believe that legal capacity is a construct devised, drafted from time to time, be majoritarian views on best interests of society on the pretext of best interests of individuals.
Harish, firstly, I would say I agree with your comment. As far as your question is concerned, on the relationship between unsoundness of mind and lack of legal capacity, even as we've brought in some kind of like so-called changes, in the main, unsoundness of mind is, of course, is a legal term of art. It's not really speaking any kind of condition which subsists. It's more to do with, what the law sees as an essential ingredient, an essential, characteristic a person should possess. And the absence of that could get you to be seen as of unsound mind. So you would find that unsoundness of mind, how you define it may change from context to context. You would find that, okay, when you're talking about, like if supposing you have a provision in the Marriage Act, in the Hindu Marriage Act, which allows for divorce on the ground of unsoundness of mind. And of course, the unsoundness of mind should be of a kind where you can't expect the petitioner to any longer live with the respondent. That's the kind of point that you're making. Now, unsoundness of mind here, to a large extent, will depend upon how do you expect, say, if it's a man seeking a divorce from his wife, what are the societal expectations of how a woman in a marriage should be operating? So I mean, when I was, it's been some time, and hopefully we're getting better case law now, but it would be like things like a refusal to consummate marriage, talking to strangers, being disrespectful to the elders, was provided as evidence in a court of law of the woman not being of sound mind. It's not like that's the only thing. Along with it, maybe, some prescription of some depression or some medication or something. You combine a certain kind of a potpourri you create, and then you say, oh, this demonstrates that person is of unsound mind. And you come into like the whole area of contract, you'll find another kind of exposition happening. When it comes to, say, compulsory commitment to mental hospitals, and you're talking in terms of somebody being, some kind of treatment being imposed on that individual. The kind of evidence which comes in there very often is that anyone who doesn't, the second part of your comment, anyone who doesn't want to live their lives according to whatever is an expected way of operating could well invite a charge of not being of sound mind. Because the legal construction of soundness of mind or unsoundness of mind is a distinct point in law. Unsoundness of mind is largely when you are acting contrary to whatever society expects.
Samachar apartment. Mayuri extension.
Somebody has their microphone on. And Samachar apartments, someone has to reach. I don't know what is.
We've unmuted her. Yeah, you can continue.
Yeah, I mean, I think for basically, this is the way in which the law creates, largely in the way in which you have legal capacity being spoken of. It's not supposed to be in, okay, let me say it very quickly to you. There are three ways in which unsoundness of mind and legal capacity get constructed in the law. One is just by, if you are a person of unsound mind, which could mean that any kind of a psychiatric diagnosis, could mean, sort of behavior which is very contrary to what a society expects. You could, just by that status or by that diagnosis, be seen as not having legal capacity. The second kind of test that you have in the law is the functional test, where you then say you are of unsound mind, say if when you're entering into a contract, if you don't understand the terms of the contract or how it will impact upon you, then you are of unsound mind. So it's not just the diagnosis, it's the diagnosis resulting in a specific kind of functional incapacity. Very often people used to believe that a functional test is it's okay, it's it's not discriminatory. But the question that has to be asked, Harish, is that this question is not asked to everybody. It's only asked if you have any kind of, if you have a psychiatric diagnosis, definitely gets asked from you. If you're a person with intellectual disability, definitely gets asked to you. So but it's not like, everybody is asked that whether you understand the terms of a contract or not, because a large number of people who are not literate, a large number of people who as such are, like the people who kind of like put their thumb impression on a whole range of horribly extortionate contracts, nobody calls them of unsound mind. So it's to that extent, yes. So that's the second test. The third is where you talk in terms of somebody lacking capacity if you make decisions of a kind which the law doesn't approve of. So if I go to a psychiatrist and want to seek treatment, nobody questions my capacity. It's like seen as demonstrating my good judgment. But supposing after I go to the psychiatrist, I don't much care for what the psychiatrist is doing to me, and I want to stop the treatment. So it's a consequence or a decision that I have taken. You actually have provisions in the law by which the psychiatrist, by creating a medical board, can actually have somebody else determine that this particular treatment is needed, even though the person who's seeking treatment is not wanting it. So these are the three kinds of ways: status, function, and consequences, by which the law makes a relationship between unsoundness of mind and legal capacity.
Before moving to other questions, I'd like to request everyone to send their questions in the chat box. So Sadamini is asking, does the provision of legal capacity in Rpwb section 13 apply to individual problems only, or can be applied in a generalized aspect?
I would want her to clarify what she's saying. What does she
So
mean by
Damini,
between individual and generalized?
Thank you so much for giving me this opportunity to ask this question. I had this question. Can you please spotlight Sodamini? I'm not able to see her video that well. Hello?
yeah, 1 second. There's a technical glitch. We're doing. Yeah, so Damini is pinned.
Thank you. Thank you for this opportunity for letting me ask this question. This was a great lecture. I really liked it. My background, I wanted to give you my background. I'm a deaf person. I wanted to share and I wanted to ask you something. So some argument was happening. There was a debate. There is a debate in the deaf community that I wanted to ask about who can teach Indian Sign Language and who cannot. If a hearing person is teaching sign language, or only a deaf person can teach sign language. There's a debate here. There is, there are different opinions about this. The Rpwd Act, there is a section 13. There's a section 13 which talks about the legal capacity. And if the person is deaf, can they teach? Can only they teach Indian Sign Language, or can they tell the hearing person that, hey, I am the deaf person, let me teach Indian Sign Language? Or or if a hearing person is approached in such a situation to teach sign language, they bring a deaf person who can teach. So basically, she's saying that the principles should be decided by the deaf person, or any disabled person should independently be able to decide. Like that should definitely be given to them. If it's their, their job opportunity should not be taken away by somebody else. Right. And I want to ask you this, about section 13. If it, if this impacts, if for example, in my human rights, does this impact my my legal capacity or not? If does it apply or not in this kind of a context?
Section 13 doesn't apply. I mean, section 13 is dealing with an absolutely different issue. It's more into the factor of people who were disqualified from being able to make their own decisions. The point which you are making, Sodamini, is a very different one. You are talking more in terms of participation and choice and voice, which is not what section 13 of the Rpwd Act is talking about. But I do think that the argument you are making is worth making. It's like because not from so much from the Act, but from the convention. And the convention speaks in terms of a right to participation. It speaks in terms of, like, it's not just a question of opportunity. It's a question of that when a hearing person, I'm not making a dichotomy, because I genuinely do think that this business of who's disabled and who's not, or like the so-called categorization of non-disabled is also problematic. I'm one of those people who believes that we need to break these categories down. But irrespective of that, one has to still recognize or experience the fact that possibly if a deaf person is teaching sign language, there may be something that you're bringing in addition to what it means to both, as a communication thing, what it means, as well as the person who's learning what their difficulties may be. You might appreciate it more. And that's, it's like all things being equal, this preference should be given. That's how I would see it. That's how I would see it. But the section that you are quoting has nothing to do with it. It's on a different matter altogether. Yeah.
She just had a little doubt. That's why she asked it. Okay, thank you.
Sure.
Okay, thank you.
She was a little confused about this and wanted to ask you, because this is a long debate going on in the deaf community, and she wanted to ask.
I feel the debate is good, but the section is wrong. I could possibly, if you write to me separately, provide you with a linkage of a more appropriate legal provision to make the argument.
All right, okay. Can you send her details where she could contact you and write to you?
Sure. I will share.
Thank you so much.
Sneha or Barsha can sort of share it with you.
Sure. Mr. V. Jay Kumar has asked the question. Have been coming across many cases of people in coma states or advanced dementia and families seeking some sort of access to the affected individual finances to fund their treatment. What facilities exist under current laws in such situations?
Well, you see, one kind of substitution is, of course, the nominated representative, and the Mental Health Care Act allows for nomination to happen. And it's like it's even if you have not nominated, there is a list there of people who can be acting in substitution for that individual, so that list gets activated. The difficulty, of course, is this, that even if supposing you don't have, you have a family member, you have a guardian, but you also have that supposing somebody has been employed as your substituted representative, even that person can end up making a decision which is problematic. But it's not like family members can't get access. In the law as it stands, they can.
But that would be, this is Vaishnavi, that would be kind of restricted to mental health issues, right? So there are cases of people who have had, pretty severe strokes and who are, disorders of consciousness and things like that. Okay, one could say that, all right, with, family members of people with dementia, we could still, kind of fall back on the nominated representative bit. But for a lot of people who, either a traumatic brain injury or stroke and things like that, and it looks like it's like a pretty chronic, state of affairs, there seems to be nothing. I mean, they are quoting the National Trust Act, they're quoting the Mental Health Act, they're quoting all kinds of things. And even the courts are saying that there seems to be no facility for such people, in which case,
see,
isn't that a gap?
No, I mean, see, the thing somewhere is this, that a large amount of decision making for you could say people who are at the intersections of the physical and the mental impairment happens with whoever is the guardian at that point of time. I mean, when you're taking informed consent forms, which is the law under which you're taking it? You're just taking those forms, no?
That would be under the medical aspect, right? But we're looking at...
Yeah, I get it. What I'm saying is this, that on the other hand, when you are talking in terms of what should I say? When you're talking in terms of management of, one is of course the, like if you've arranged your affairs in a manner where somebody is a nominee, then that nominee takes over in a point at which you are dysfunctional. It's a kind of a expansion of how substitution actually happens all of the time in how treatment decisions or even, your other property and other work decisions happen. It's like, and it's primarily you could say an expansion of. To be saying that you need a specific kind of a law for those kind of situations, I think we've been carrying on without a specific legislation by saying that, okay, these breakdowns happen in life, or these accidents happen in life, and in those accidents, we could say what you consider to be best for that individual is done. You sit in the armchair of that person and you do it. And it's not just limited to medical. I feel it's as much too. The only thing is, if you are saying to go to a formal process, what formal process is available? Maybe none. But I don't really think that these things are all done necessarily through the formal process. And usually you will find, in fact, what my work has found for me is this, that nobody really went to the law unless there was a dispute in the family. One person was saying, this is how we should be managing affairs, and someone else was saying the other. Then you kind of said, acha, let's go to the court and say who's authorized and who can do it. Otherwise, you'd say just make an inter se arrangement and things happen.
Okay.
What I'm trying to somewhere saying is that, actually speaking, if you ask me, a lot of life happens oblivious of the law, or in fact around the law, not literally through the law. And it's of course also requires that much of a creative understanding of the law. Okay, which particular part should I look at? We talk in terms of advanced directives, but you look at the advanced directive provisions in the Mental Health Care Act. I would never use an advanced directive, because actually speaking, all of the law is just telling me how my advanced directive may not be followed. It's not really saying how they are going to follow the advanced directive. But ordinarily, yes, you should be nominating somebody. You might be having a, making some kind of arrangements if you feel that, your financial and other affairs are so complicated that it would mean. Otherwise, whoever is your next of kin just takes those decisions. And we are a society which allows for them to happen.
We'll share the two cases in the chat box so you could take a look at it later.
Sure.
Okay, I'm moving to the other question. Akhil Paul writes, is it because the overall environment in the country is about projecting PWD as Divyang, which is further alienating from them from legal capacity as well as inclusion? We are entering the 5th year of Rpwb Act. So can we ask the Supreme Court to set up a committee for legal audit?
Why do you want the Supreme Court?
Because no other court can do nationally. High courts, depending on the states, they limit their.
Yeah, but if the Supreme Court gives you some shitty order, you're done for.
What's the way out then?
I would somewhere say that if you feel that you require an audit, ask for a smaller one, ask for it in your particular state, ask for it in a specific time. Don't ask for a unit. Don't ask for anything which is for the whole country. It's a bad idea. And definitely not from this Supreme Court. See, what we have to understand, like Saudamini a little while ago, I'm just kind of making a connection, Akhil. Saudamini a little while ago was saying that when it comes to teaching of sign language, preference should be given to deaf people. And the underlying point of her question was also this, that there is a certain kind of competence I possess, which may not be there, or this is a specific kind of job opportunity which should be there for me, and it shouldn't be like somewhere taken away from me. Both kinds of points were there, as I think underlying the point, that the question that she was raising. When it comes to the whole question of the audit of the law, or the necessity of forming a committee, you are people who have done virtually 3/4 of services which are available for people with disabilities came from the community. Why is the audit of the law requiring the Supreme Court? It's your law, you audit it. Every time you go to an authority, then when you go to the authority, you have somebody saying, okay, we're going to do something for the Divyangs, and then we have problem with it. But necessarily, that's all their understanding of the issue. We can't have it both ways. No, we can't say we possess a certain competence which is not possessed with the rest of society, and yet we go there and we ask them to intervene, to do something about an issue on which they know nothing.
Yeah, but unfortunately, they are the ones who are implementing the law.
No, that's exactly where I'm saying, Akhil, that if you were to set up the audit yourselves, it would, one, be a more genuine kind of an audit. And then to speak in terms of that audit obtaining recognition, or that audit, you talk about it in 20 different places, but think out of the box, yeah. It is not the time to go to the government and the courts.
You're right.
I mean, I personally feel this is the time for citizens to assert themselves everywhere.
True. I agree.
So that's where I'm coming from, that why do you want to go to the Supreme Court?
Yep. Thanks.
Moving on to Dr. Sharad Phillips' question. Should diminished responsibility coexist with universal legal capacity?
Okay, basically you're saying that whether the insanity defense or defense on grounds of insanity can survive when we are talking about legal capacity. Am I right, Sharad?
Yes, ma'am, you are. That's correct. That's precisely my question.
Okay, say, Sharad, these are one separate things. When you speak in terms of the defense of insanity, the defense of insanity, of course, one, it's like, it's largely about acquitting people on the ground of insanity, and acquittal doesn't mean discharge. That's one thing which is important for us to appreciate and understand. So when you speak in terms of diminished responsibility, or you speak in terms of the defense of insanity, virtually everywhere, when you accept the defense also, it doesn't mean that the person is set free and is out into society. Lots and lots of times what you are doing is that when you are accepting the defense, you are still keeping the person in custody because the person is not considered fit to be sent out into society. And those provisions in the law continue everywhere. Okay, even if we keep that aside and say that we have started asking some questions around when people should be discharged, and as a result of which, at least you're not making it a lifetime kind of confinement, you have started to ask questions on, when can they be released, or when can they be set free, and all those sorts of things are happening. So then it's important to be asking, what is the purpose of, why do we have a defense of insanity? Now, one kind of interpretation, Sharad, which is put out is that you have the defense because otherwise, if you just stayed with the whole notion of intention, that you needed to have the intention to commit an offense, and if that intention is absent, the person will be found not guilty and is out there. You can't do anything to that individual because you felt that people with so-called mental disorder or any kind of disturbance could be dangerous to society. You brought in the defense of insanity as a way of keeping them in. You've held them non-guilty, but you kept them confined. That's one. The other thing is also this, that the reason why any society, and let's forget about the defense of insanity, look at mistake, look at the manner in which you look at private defense. Why do you have the defense of, when your private defense is primarily where you allow a person to go as far as to even kill another person to save their own lives. So you are recognizing the fact that when it comes to your own survival, you will do anything to survive that day. You are not going to think that, oh my God, I'm killing this fellow, this will be seen as murder and I will be hanged for it or something. You don't think of that. You're just responding with your immediate reflexes and you're trying to save yourself. And that's the reason why the law has a provision on self-defense. It says that, yeah, it should be proportionate to what you see as your danger. You should also only use it if you can't get access to public authorities, but you actually recognize it, which can go up to killing another person if required to save your own life. So the entire business of defenses for all individuals, and I'm not talking about people with disabilities, has got to do with a society choosing what it wants to punish and what it doesn't want to punish, what it cannot punish, what it should not punish. When you speak in terms of, say, necessity, you have actually a defense of necessity. You say that, all right, fine, if there is like to avoid a bigger evil, if you commit a smaller evil, it's permissible. So the defense of insanity, if one was to see it in that manner, it is about saying that, all right, this in some way undercuts the intention of the individual, hence to punish this individual for something which that person could not have prevented is not how a civilized society should act. What are we talking about in legal capacity? In legal capacity, we're talking in terms of autonomy and choice. We are saying that, all right, an individual, as far as we should have the freedom to be able to live their lives according to their own best judgment. I used to always, it's not absolutely opposite, but I hope you'll bear with me. In some manner, it comes back to the question that you're raising. We used to have this constant discussion, Sharad, on the difference between support and substitution. That what is it that support can do, which guardianship could not do? And I used to say that, okay, when you have a guardian and somebody is substituting for you, that person is obligated to do something which is in your best interest. So when it comes to, like, say, like you have, say, 50,000 rupees a month is something that is your, the emoluments which are available to you, or the resources, financial resources which are available to you. 50,000 maybe is too large. Maybe say, let's say 25,000, whatever. And if I am the guardian, I am supposed to spend that money in accordance with what is considered to be the wise way of spending it. I am not in any which way obligated to consult you in how this money should be spent. But if I'm, on the other hand, your support person, and you say that, listen, we have this 25,000 rupees. This is what has to go into your rent. This is what will have to be given for food and something. And that's about it. And the money is over. And say, supposing, I can maybe, we can have a non-vegetarian on certain days. We can have a certain kind of a feast 1 or 2 days, but that's about what this money takes care of. But I am like somebody who just loves to go to watch movies in a movie theater. It's like, that's what keeps me alive. That kinds of, I can have dal roti for 10, 15, 20 days, but if you give me at least 4 outings, if I am a guardian and I was to do that to you, I would have somebody sort of pointing a finger and saying, I am misusing, I'm misappropriating, I'm mismanaging your money. If I'm a support person, then the will and preference of the individual whose property I'm managing is an equally significant dimension. So legal capacity is addressing those questions. The whole question of diminished responsibility, the whole question of defense of insanity is about who should we punish or not punish in our society. And it's not something uniquely done for people with disabilities, it's done for people as large. I've quoted you the defense, self-defense. I've quoted to you the whole defense of necessity. There is this question of mistake of fact and law. There are a range of defenses. We also have something like grave and sudden provocation, which a lot of feminists are saying is a very, very male standard of like what causes you to commit an offense. It diminishes your responsibility if you did it under grave and sudden provocation. And typically the cases which are shown is a man finding his wife in bed with some other person. And that huge provocation that caused is enough for him to kill the wife or kill the man or whoever is. And as a result of which, his offense would not be an offense of murder, but the lesser offense of culpable homicide, not amounting to murder, or in popular language, what you'd call as manslaughter. Now, how much of that has got to do with to be saying, what the hell, yeah? I mean, okay, you found her, you divorce your, what does it mean that you can go as far as kill? But in allowing for or in providing for that provision as a society, we are saying that no, a man's sense of possession has been so offended by seeing his wife in the in sexual congress with some other person, that it is absolutely permissible for him to kill that man or kill the woman. You're getting my point? And what I'm trying to say to you is this, that when we see these two things together, what we'll end up doing is this, that we don't see the social choices which inform these defenses. And to say that these two can't subsist together, because the defense of insanity, I started out by telling you that it actually means that you can keep the person in for the rest of their lives by giving them the defense of insanity. And only a very bad lawyer argues for the defense of insanity in any offense other than where the alternative is that the fellow could be hanged.
Thank you, ma'am. That was very lucidly explained. I actually wanted to mention about a particular case where there was a person with moderate, mild intellectual disability who we had seen had been perpetrating sexual abuse. He'd been grooming children and he'd been doing these things. And later he started telling that he has also been a victim of sexual abuse. And so there was a lot of intersection here, and we were trying to wrap our heads around this, whether this person would, like, because this person had presented to us during his adult years at the age of 19, and the POCSO requires us to report on these things. So how does one really wrap about this? That was my question. That was the underlying case on which this premise was based. So that's very lucidly explained. Thank you.
Yeah, because basically what I'm trying to say is this, that it's like I can be a competent person and yet be somebody who does something which maybe I need some exoneration for. For us to think that because I am, I have legal capacity, I can't make mistakes, or I can't be vulnerable. It's a sort of a standard that we put out, which is unrealistic. It's not how we are.
The persisting dilemma.
I mean, the POCSO obligation itself, I find it's hugely kind of problematic. It's asking us to be complicit with the state over whoever is our client or our patient, or our, I find that hugely, hugely problematic. Maybe, like as a professor of law, I'm not a very obedient follower of the law.
Yes,
I'm a very critical follower of the law.
Right. Thank you so much, ma'am, for that. But persisting with that, ma'am, the question there was like, you mentioned if I'm competent, I'm also allowed to make mistakes. Yes, but any other person making that mistake would be suffering consequences. But because of this diagnosis of intellectual disability, this person may not really be punished for this act. And there is no provision which was allowing, actually, because we ran into some troubles here, because we tried to report this to the CWC, and they said that there's no way for us to report a perpetrator and then go and identify victims who could then lodge complaints against this perpetrator. So that was the pickle that we were in. That,
I'm sorry, I missed you. I'm sorry. Please, Charlotte, if you could just repeat it.
Yeah, I'll just repeat. So, ma'am, what happened was when this person came to us, we got to know about all these incidents of sexual abuse which have happened. And they were almost like they had been changing houses in localities. They were from the lower socioeconomic status, and there were multiple complaints which had been going on. Everything had been hushed up. So this was a time where the perpetrator himself has been brought here. We got to know about it. We tried to report. So through the POCSO, we saw that there's no way for us to report a perpetrator. We can only report victims who've been there. I mean, technically, yes, that should also be allowed, that we could report perpetrators and there should be some sort of action that needs to be taken. But that didn't happen. We went to the CWC. They referred to the local police station. The local police station said there have been no such acts which have happened here. They are not aware of it. And there are no victims who have come forward. So here we are left in the lurch here. This person in the technical sense of things, because of intellectual disability, will most probably not be judged competent to stand trial or any of those things. But at the same time, there is a failure of the entire mechanisms to safeguard the general public, or at least look at some sort of restitutive help for this person. So, like, that was a debate that we were having amongst us care professionals, and we really needed to understand this, how diminished responsibility really does work here. I mean, those terms are not there in the Indian law, is what I understand. But
no, we don't have. See,
yes,
diminished responsibility comes in a manner of speaking, like more by when you don't recognize. Okay, let me say how it comes in, Sharad. It is like there is not an explicit provision, but when you plead, say, the defense, and the defense is turned down, it's not accepted, but it sort of still influences the kind of punishment which is given. You recognize, you may reduce the punishment, because you'd say, okay, this fellow is not all there. He's not part of Section 84, but he's not all there, and hence you kind of punish him lesser. So diminished responsibility comes more in the sentencing rather than an explicit substantive provision of the law. The other thing which you are narrating, it's partly what I was also saying to Akhil, it's like the fact that the law is not providing a process by which something is to be done doesn't prevent that, if supposing this perpetrator requires support for the sexual abuse he or has himself experienced, or requires, other kinds of, because I think we would be really living in some fool's paradise if we think sending people to jail does anything good for them or anything good for society. But there's nothing at all preventing you as a person who's concerned with the issue to work out an intervention, because the law is not preventing you from doing it. It may not be facilitating you from doing it. You get my point. It's not that when you do it, you're doing something illegal. There are a whole range of areas which are open for us as citizens to do things on. We don't necessarily have to go to the local police station to do it.
I'm sorry, ma'am, because we would be breaching confidentiality. So that's one thing that.
No, my thing somewhere is this: it is like something that is where the possession of legal capacity becomes useful. Yes. Because you can do it in consultation with this individual and say, listen, you evidently need this help. And we would be happy to provide it to you. Because then you can have a conversation with the individual. You don't need confidentiality and all of that. See, I can always waive, no? I can say, yes, I need help. You provide me that help.
Right.
But I'm trying to put forth to you that there's a third way also.
There's a third way, yes. I get that. I see it, yes.
Thank you so much. That was a very elaborate question answer session. Ma'am has already given us more than 1.5 hours. I would like to request all the participants, if they have other questions, they can write to ma'am if she is with that. And I can put her contact details on the chat box. And participants can write to ma'am and directly ask her the questions if they have, or write to us and we can forward the same to ma'am.
Vaishnavi, could you send me those? I don't know whether this chat will stay after this is over. Yeah. So if you could send me those citations, I'll have a look at those cases.
Absolutely. I'll send these citations, and I would like to.
Yeah, will do.
Yeah. I would put the contact details on the chat box.
Yes, please do so.
Okay, I would like lastly to request Anjdeep to comment, and she wanted to say something. So briefly, Anjdeep, over to you.
Thank you, Varsha. Good evening, everybody. Am I audible?
Yeah,
yes, you are.
Yeah.
Thank you so much, Professor Dhanda. I wanted to thank you on behalf of HRLN, but I'll go in my gratitude today. I'll go from micro gratitude to gratitude on the macro level. So, you have really opened our minds today. This was our first lecture in the Disability and Law series, and I think all of us have family members who live with mental health issues, and I have a family history of mental health issues. And today you have really opened up my mind to what it, to really question that, is it the ability to reason which defines a human being? And if not, then what is it? What does it mean to be a human being? And that the inherent humanness, as you said, that is pre-culture. So thank you so much for doing that. On the professional level as well, you mentioned stateless persons, migrants, refugees, and that is the area of law that I work on, and many of us here, yeah. So we are really, even on that level, you have really opened this question to us. So since you have given us so much to think about today, ma'am, I hope, and all of us hope, that you will come back while this series is going on to take other lectures, at least one other lecture with us, ma'am. And thank you so much for taking out so much time for us all and enlightening us with this lecture today. Thank you so much, ma'am.
You know, Rajiv is a total bully, so he'll get his way.
Taking forward Anshul's message. Thank you so much, ma'am. It was a very enlightening and informative session. And we'd like to have you more often and have such sessions more. Thank you, Ananta, for your excellent contribution. And I'm looking forward to having such lectures soon. Thank you to all the participants. I've sent ma'am's email ID on the chat box. You can just check it. And thank you for remaining with us for this lecture.
Thank you so very much. Thank you, Rajiv, and thank you everybody else. It was fun.
Yeah, same here, ma'am.
Thank you, Professor Dhanda. Great having you over.
Thank you, Rajiv. Thank you so much.
See you again. Bye-bye.
Yeah, sure. Bye.